Chairman, I speak in support of all the amendments, proposed amendments to the bill. I'm glad that the government took on board many of the suggestions of members to move amendments to improve the bill. This will plug the various loopholes in relation to safeguarding national security that will form a better barrier to protect national security. Now, there's a time limit, so I will speak twice. First, on Clause 47. Now, on Clause 47, sabotage endangering national security. During the 2019 Black violence, many rioters sabotaged and damaged public infrastructures, including transport infrastructure. They even stormed the Legislative Council. And many rioters actually used various means to damage the transport infrastructure. That's their first target because they want to stop people from going to work. That brought about both tangible and intangible damage to Hong Kong. That's why with sabotage and endangering national security, the clause needs to be all-encompassing. Now, in the definition of public infrastructure, members noted that this definition does not cover, say, container terminals, public transport infrastructure, and so on. Let's say if someone bombs a container terminal or sinks a ship, then that will, to a certain extent, disrupt our logistic activities. Now, Hong Kong, of course, is an important international financial center. So the Hong Kong Exchange has a significant status, so it needs to be covered under public infrastructure. We don't want people to exploit the loophole. For container terminal, the government said is actually a transport terminal. They know it's impossible to include an exhaustive list. That's why there are various ways to explain what's meant by public infrastructure. But then we're talking about important issues. It's important that the government makes clear provisions. So we want the government to cover a wider scope and to give more clarity to the provision. I'm glad to see that the government agrees that the term public infrastructure should cover container terminals, public transport infrastructure, the Hong Kong Exchange, in particular its central clearing system as a financial infrastructure. And also, in the light of members' views, the scope of public infrastructure is clarified. And so that's why in Clause 47, bracket 4b, public transport infrastructure or the word public are added. And then for C, bracket 1, the following item is added before providing, and then or maintaining is added before public services. And then finance, logistics are included too. And then there's also capital A and B infrastructure and facility. So after amendment, it's like this is now a tight-knit this definition. People won't be able to exploit any loophole. So I'll stop for now. I'll speak again later on various restrictions on absconders. Thank you. Mr. Tommy Cheung. Chairman, I speak in support of all the amendments proposed by the administration. I'd like to speak on two amendments in this round. Clause 47, sabotage and endangering national security. I want to talk about Clause 47, bracket 4, public infrastructure, the definition of it. Now, we want to make the definition clearer, and then it's will cover all major infrastructures in Hong Kong. So, airports and other reference facilities ought to be included, and then container terminals should be regarded as a form of logistic infrastructure, and then the central clearing and settlement system of the Hong Kong X should be regarded as an infrastructure for maintaining financial services. So all these infrastructures are important for Hong Kong to maintain its status as an international aviation, shipping, logistics, and financial centers. So this is important to make sure that we perform our function as hubs or to provide various public services. We don't We need to prevent people from damaging or paralyzing these facilities to endanger national security. This is something the business sector has been asking for all along. Now, for the term public infrastructure, there is a non-exhaustive list of examples. This is to clearly explain the meaning of public infrastructure, and that is, it shouldn't just be restricted to the terms included in the clause. So this is important. We need to explain clearly the term of public infrastructure. I'm glad that the administration has taken on board of the views of the business sector. Clause 53(1)(b), Roman numeral 5. The amendment is to amend clause 53, the meaning of using improper means. In bracket 1, bracket B, bracket numeral 5, improper means refers to causing psychological harm by undue psychological pressure. Now, this is referring to the UK National Security Act 2023 that is section 15 bracket 2 bracket E. This is modeled on that term spiritual injury in this section. But then spiritual injury covers the act of one person to another person in relation to the harmful impacts on a person's spiritual and religious well-being that could be directly caused by another individual. For example, excluding a person from the membership of an organized belief system or banning them from attending a place of worship. Now, this is not in line with the actual circumstances in Hong Kong. It is also not in line with the legislative intention. So the administration agrees to my point. So that's why the administration is moving amendments. It's no longer making reference to the term used in the UK Act, which is unsuitable for Hong Kong's case. Instead, it proposes to use the term psychological harm. And then for 53(1)(b) numeral 5, so the term psychological harm is used to replace mental injury. And also, the term undue mental pressure is replaced by undue psychological pressure on a person. We believe this is more appropriate and is more in line with the policy intent. We're happy that the administration has taken on board our views. I'll be speaking on other clauses later. Mr. Lai Tong Kok. Chairman, I speak in support of the 91 amendments moved by the administration. In the course of deliberations, the Bills Committee considered every single clause and every single word used in each clause. We want to make sure that the provision is the best construction, then the most succinct, and so on. Now, here are my views on the proposed amendments. The clause on making subsidy legislation is a new one. I note that some media organizations expressed concern about the new clause 106A, capital A. That is, the Chief Executive Council is given the power to make subsidy legislation. So there is actually further refining of on the implementation of measures to respond to unforeseen circumstances. Now, clause 106A is actually a forward-looking clause. It will further strengthen the protection net in safeguarding national security. Now, the making of subsidy legislation is a well-established practice in the common law system. The purpose is for the executive to make subsidy legislation that will come into immediate effect as necessary after the enactment of the principal ordinance. Now, since the legislature allows the executive to perform such a task, it is the usual practice. At the same time, though, we retain the power to amend or repeal a subsidy legislation. That is the advantage of the negative vetting procedure. And also under this mechanism, more importantly, the subsidy legislation cannot go beyond the scope permitted under the principal ordinance. If that's the case, a court may rule it as ultra-virus, and then the subsidy legislation will be rendered invalid. I can give you an example. Now, for if for 106A, if the administration makes subsidy legislation, then if in the principal legislation say the maximum penalty is 10 years, then can the government raise the maximum penalty to 20 years or 30 years of a sentence of imprisonment in the subsidy legislation? Now, it cannot be done because it's stated clearly in clause 106A. Any subsidiary legislation made under this section may provide for offences with imprisonment term not exceeding 7 years. In other words, it's not possible to raise the imprisonment to 10 years in the subsidy legislation. Otherwise, it's ultra-virus. Now, I believe the general public are not unfamiliar with subsidy legislation. I can give you another example. When we had the COVID epidemic, the government often exercised its power under Cap 1559 and use the power given to it to make subsidy legislation for preventing and fighting the epidemic. Now, I just did a quick search on the internet, and I found that under Cap 559, there were subsidy legislation from A to L. So in total, 12 pieces of subsidy legislation were made in the light of COVID. And then for say for the definition of public officer, I find that the definition to be too narrow. So for persons in public organizations with important influence, they are not covered. We want the public officer to be more forward-looking, so we propose the government to amend this so that for the purpose of endangering national security, the administration may make subsidy legislation, expand the scope of the definition of public officers. This is to ensure national security effectively. So this is that's why the government is doing that. I will speak again later.
Dr. Kennedy Wong, Deputy Chair. I speak in support of all the proposed amendments. I'll now explain on some of the amendments I proposed myself during the Bills Committee meetings. On Clause 47, on the application for extending detention period, I mentioned about whether there is a need to give a definition to reasonable period. In its proposed amendments, the government mentioned there should be a 7-day plus 7-day arrangement for extending the detention period, stating clearly that the extension for detention period should not exceed 14 days so that the system would not be abused by defendants to delay the legal proceeding. This also shows that the administration has a determination to protect human rights and that it is balanced between and safeguarding, national security. Also, there is a provision about defendants being kept in custody by the police. I asked whether the relevant provision may shall be changed to shall. I also asked whether the defendant should be kept in custody by the Correctional Services Department instead, as the police should use the time to conduct investigation. In the end, in its proposed amendment, the administration removed the word may, and in the English version, may is changed to is to, meaning that the arrested person is to be delivered to the police officer. In Clause 76, the original version states that in national security cases, in a view of circumstances, relevant persons may consult lawyers. Well, I belong to the legal sector, and I think the term lawyers is too general because it can refer to solicitors or a law firm or a barrister. Therefore, I, along with other members of the Bills Committee, proposed some amendments. The administration agreed to the amendment and to revise the instances where lawyers were originally used to legal representatives. Also, there is a newly added provision stating that a legal representative can mean a solicitor or counsel. Clause 76 also states that the police may apply to the magistrate to restrict the legal representatives that can be consulted by the arrested person. I mentioned that this may tarnish the reputation of the law firm involved or concerned. I asked whether the relevant public hearings can be held closed door so that the relevant law firms or lawyers involved, their identities will not be disclosed. On Clause 93, on the issue about cancelling the passport of the absconders, if the absconder does not apply for another passport during the absconding, then this would allow the arrested person to delay the legal proceedings. So I'm happy that the administration took on board my views. I will speak again in the second round. Mr. Stanley Ng. Madam Chair, I speak in support of all the amendments proposed by the administration. There are in total 90 clauses in the amendments. During the highly efficient scrutiny of the bill, members of the Bills Committee discussed over 1,000 questions. These 90-some clauses showed the highly efficient and effective discussions we had. There is refinement of the wording used in the provisions. For instance, the amendment proposes that the Chief Executive in Council can, by way of subsidiary legislation, specify public officers that should not be subject to incitement. There is also a part added to regulate shadow organizations of prohibited organizations. There's also a part about restricting absconders to allow flexibility for the Secretary for Security to specify who are absconders. There is also a part about Director of Immigration not having to process application for SAR passports made by absconders. There are also amendments concerning offering protection to officers involved in national security cases. And the proposed amendments also stipulate that public servants have to assist in work on safeguarding national security. All these amendments allow the administration to be more flexible as it handles work concerning national security. All these amendments improve the provisions and it allows the administration to better safeguard national security. In event where there are incidents that endanger national security, these provisions allow the administration to be flexible. Also, there are amendments concerning the role of the National Security Committee. It clearly sets out the duty and role of the committee. In the newly added clause 107A, it states that the National Security Committee may provide advice on matters relating to national security matters, and that the committee can make a judgment, and the judgment and decisions made by the committee should be followed up. This sets out the duty and functions of the National Security Committee, and this allows the bill to achieve convergence and compatibility with the Hong Kong NSL. Madam Chair, I'll speak about national security education in my next round. Mr. Tony Che. Thank you, Madam Chair. During the scrutiny of this bill, the Bills Committee raised many views and suggestions. The administration, after careful consideration, has taken on board our views, and that in a highly efficient manner the administration proposed this committee stage amendments. In the Chinese version of the amendments, 91 clauses are involved concerning 20 sets of amendments. In the English version, there are more amendments. There are also ones that concern the use of wording in English so that English speakers can have a better understanding of the bill. I thank the hard work of the administration. Clause 86. Concerns revoking all kinds of professional qualifications obtained by the absconders, and no one would be allowed to provide fundings to the absconders according to the bill. In the original version, it states that it is only after 6 months after the issue of the warrant that the Secretary for Security can specify a person as absconder. Other members and I were perplexed about this particular provision. This is because in reality, we know that a lot of absconders who have left Hong Kong act in a very high-profile manner. They badmouthed and smeared against Hong Kong, and they do all kinds of acts and ask foreign governments to sanction people in Hong Kong. So why should we give 6 months' time to these absconders and their accomplices to remit money to Hong Kong, which would favor their actions to smear China? So I'm glad that the proposed amendment will better sanction the absconders, and that according to the amendments, no one would, simply because they have previously entered into agreement or contracts or have done businesses with absconders, to breach the law. Also, the amendments empower Secretary to grant license so that innocent third parties may disband or accompany or sell a co-owned property to protect their interests, and at the same time, the absconder concerned would not benefit from the company or property concerned. So all these amendments deserve our support. Deputy Chair, I so submit. I will speak again in the next round. Mr. Holden Chow. Madam Chair, I speak in support of all the proposed amendments made by the administration. I am glad that I had the opportunity to take part in the scrutiny work in the Bills Committee. All 15 members of the committee worked very hard, and we raised many questions and constructive comments during the meetings. I would like to give my special thanks to the Secretary for Justice as well as the Secretary for Security for their explanation during the meetings. During the scrutiny of the bill, they were happy to take on board our views. They listened to our opinions, and this shows that the executive branch and the legislature has been interacting in a healthy way. And this also shows that after the improved electoral system, the governance has been effective. I'd like to speak about Clause 74. Some members spoke about this clause as well. I'd like to further talk about this clause. It is about an arrested person being detained, and that the hearing may have to be adjourned during the detention period. In the past, in some magistrate courts, when a criminal case is handled, some defendants may say that they have yet to engage a lawyer, and the magistrate would allow the hearing to be adjourned for, say, 3 to 4 weeks. This is very common in the magistrate courts. In the original version, it says that the magistrate may adjourn the hearing for a reasonable period of time. Well, you may wonder whether 3 to 4 weeks is considered as a reasonable period of time. We proposed an amendment in relation to this clause, and I'm glad that the administration took on board our views to make it clear what a reasonable period should be. The administration sticks to the 7-day plus 7 days mechanism, and this is reflected in the amendment. This tells clearly that when magistrates have to handle cases where detention period have to be extended, the magistrate would act as the gatekeeper here. So I'm glad that the two secretaries have taken on board our views and proposed the amendments here. I will speak about the other amendments in the next round. Thank you.
Mr. Gary Chan. Thank you, Madam Chair. I speak in support of all of the amendments moved by the Secretary. I'd like to focus on Clause 107A, that is in relation to the judgment and decision of the National Security Committee. In the scrutiny in the Bills Committee, in Part 8, in the Safeguard for National Security, I had an observation which was agreed on by all Bills Committee members. In Part 8, the mechanisms for safeguarding national security and relevant protections, it did not mention the role of the NSC, National Security Committee. I understand we focused on the offenses in relation to endangering national security, as well as charge elements, enforcement powers, implementation mechanism, and so on. In order to make sure that the implementation of the law, that is execution of the law, are effective, we need to make sure it's clear about the top-tier design of the Hong Kong SAR government. The Hong Kong National Security Law said that the NSC assumes the role of safeguarding national security and shoulders the main responsibility. and it's accountable to the Central People's Government, including the fact that it needs to formulate measures for safeguarding national security, taking stock of the experience. Articles 14 and 47 also gave interpretations, that is, the NSC can make judgments and decisions. Any organization and individuals need to respect and execute the judgments and decisions of the NSC. So in 108, that is clause 108, the chief executive can issue any administrative order or guidelines or directions, and the chief executive assumes the role of the chairperson of the NSC. So considering the main responsibilities and role of the NSC, it is important and necessary to reflect that in this national security bill. In the bill, it should give a clear reference to the NSC Advisor Secretariat. Their role and function should be set out clearly. We need to make it clear that the NSC performs its function in accordance with the Safeguarding National Security Law regarding the actions to be followed up on. So, if Part 8 is about mechanisms for safeguarding national security and the relevant protections, we should add the role of the NSC into the bill in order to better reflect the convergence, compatibility, and complementarity of the national security law. This also sends a clear message to the community in Hong Kong. So I welcome the administration taking on board the views of me and other members, adding subclauses under clause 108 in order to respond to members' views and opinions. Reverend Peter Kuhn. Thank you, Madam Chair. I speak in support of all the amendments moved by the administration. Regarding clause 12, some members of the public does not understand the mistreatment of prison. In clause number 4, the mistreatment of treason will be amended to be a statutory provision. Well, I think this will be clearer, so there won't be any disputes. In external interference, there was much discussion in the community. In the clause external interference endangering national security has also been changed. That is, the words endangering national security is specified in the bill. This is more clearly differentiating normal commercial, academic, and cultural exchanges and other exchanges. The former is not affected. Regarding absconders, the 6-month detention period, the administration was overly restrictive of themselves. Quite some members mentioned that they shouldn't be straitjacketed by the 6 months, but the administration was very lenient. In the end, we had to sort of back the administration for changing the condition of 6 months. In the course of the scrutiny, the administration was quite restrained. We put forward some views. Some were not accepted by the administration because some may be unfair to the arrested persons or defendants. But however restrained we are, no matter how we explain to the public, we still can't stop overseas forces from smearing us and smearing the bill. We do need to think why. Many years ago, Macau already had safeguarding national security law, but there wasn't any backlash in the community. Well, I have to say that it's about those people who have an axe to grind, they have ulterior motives. Thank you, Madam Chair. Ms. Carmen Khan. Thank you, Madam Chair. I continue to speak on the amendments. The amendments respond to quite a lot of views in the Bills Committee. In order to make the bill more forward-looking and effective in rising to the complex situation of national security, it empowers the executive to draw subsidiary legislation. In Clause 106A, well, I mean it adds some clauses to under 106A, as well as the interpretation by the Standing Committee of the NPC about Articles 14 and 47 adopted at the 30th section of the Standing Committee of the 13th NPC on the 30th of December 2022. I also asked whether it is suitable to use negative vetting and whether we have drawn reference from overseas jurisdictions. The administration's reply was clear and succinct. The executive branch was empowered to make subsidiary legislation, and that is effective and that is within the law. This practice is not unique to Hong Kong. Of course, the rationality and suitability will be considered, first of all. For example, during the epidemic, subsidiary legislation was invoked and was used. The administration also referred to the jurisdictions in, for example, the US and the UK. Apart from principal legislation, different methods such as subsidiary legislation, administrative order, and practice directions were used to safeguard national security as well as to keep the law forward-looking. Clause 106 will also allow negative vetting in accordance with Section 34 of Cap 1. In my last round, I already said that the administration is restrained in its use of the functions. Under Clause 107 about National Security Committee, it reflects the complementarity with the 528 decision. It is also in line with the interpretation given by the Standing Committee of the NPC of Articles 14 and Article 47. I'm a practicing lawyer in Hong Kong. I also obtained the license to practice in China in 1995. The interpretation given by the Standing Committee of the NPC formed part of the law. That is, it formed part of the Hong Kong National Security Law. So the National Security Committee powers have been in place, making clear the power in the bill is not problematic. It is suitable to do so. Article 17(3), well, that is the relevant provisions need to be reported to the Central People's Government. If it is not returned, there is no public concerns, and public can rest assured. There were a total of 91 amendments, which fully reflects the respective responsibilities of the executive branch and the legislature. We work together to fulfill the constitutional duty of Article 23 legislation. The amended bill is more comprehensive. After finishing the constitutional duty of Article 23 legislation, there will be greater protection of national security of the nation. It's a historic mission when I can take part in the scrutiny of the bill. I support the amendments. Thank you, Madam Chair. Dr. Lo Wai Kwok. Madam Chair, this is my second round in the CSA stage. In Part 8, Mechanisms for Safeguarding National Security and Relevant Protections, I agree that there should be a top-tier design that is including the reference to the National Security Committee. Members are concerned whether subsidiary legislation could be used to deal with new situations. The administration was receptive to ideas and added a couple of clauses, including the fact that there could be administrative instructions and the CE in Council can make subsidiary legislation for safeguarding national security. This can help Hong Kong rise to the unforeseen national security risks. This is by way of negative vetting, and this is a standing mechanism of the Legislative Council. This is a successfully implemented mechanism in Hong Kong. Subsidiary legislation cannot step beyond the scope of the principal legislation. After scrutiny, the subsidiary legislation can be amended, so it is a very safe approach.
And we ought to support it. Deputy Chairman, now, we considered Part 7, Clause 96, which is Clause 90, which is about disqualification, temporary disqualification of the right to practice. And what about disqualification? Professional qualifications, the two are not the same for absconders. Now, the Hong Kong Institute of Engineers is empowered by the reference by laws to award the professional qualification or cancel it. As for practicing, we have the system of registered engineers, and it's the ERB, the Engineers Registration Board, that's responsible for the registration of engineers. So members of the Hong Kong Institute of Engineers are eligible to apply to the ERB for registration. And then we also have lift engineers, managed by the Buildings Department. So for Clause 90, if it's in force, which is about temporarily disqualifying temporarily cancelling the professional qualification of absconder. That means there is need for the relevant institutes to amend their memorandum of association to change their powers. Now, the Secretary for Security explained that it's temporary cancellation of the practicing qualifications or professional qualifications of absconders. Now, for each professional body, they may see if they need to amend their code, and the Secretary believes they need to do that. I thank the Secretary for this important clarification. Then the relevant professional bodies will know exactly what is required of them. After the passage of the bill, the relevant professional bodies need to review their own codes or memorandum of association carefully to see whether there is need to make corresponding changes. And they have the duty to do so if it's necessary. So I speak in support of the bill and all the amendments moved by the administration. Mrs. Regina Ip. The Secretary for Security mentioned important amendments, 86(2)(c), that is specified absconders only, and all this, so deleting the wordings that are issuing order after 6 months. And then there's a new 106A for Chief Executive Council to make some legislation. Some members have already spoken on that. Now, I'd like to speak on Part 6, external interference. When we consider this part of the bill, the meaning of colluding with external force, that's Clause 50 and then Clause 56, collaborating with external force, the description is the same. C, it says that if a person collaborates with external force and do an act, it could be regarded as collusion with external force. Mr. Jeffrey Lam and Dr. Wyckoff and I expressed our concern because Hong Kong is an international shipping center, financial center, and so on. There are NGOs, think tanks, academic institutes, and so on, who often have to organize activities together with external or with foreign organizations. So would that be labeled as collaborating with external force? I thank the Secretary for Security for explaining that this is just a meaning, it's not an offense. If you read the clause carefully, if you are to commit the offense, that means colluding with an external force or collaborating with an external force. There are several conditions that need to be met. Now, in this part, there is explanation of what is meant by interference. And secondly, that there must be criminal intent to bring about interference effect and collaborating with external force. And also you need to use improper means to achieve that aim. So therefore, when we work with others to organize activities or think tanks organize online seminars, well, we won't be caught by the law. It won't be regarded as colluding with external force. I thank the Secretary for taking heed of our concerns. So for Part 6 of the bill, he's moving amendment to the heading. It states now, it's external interference. Instead of external interference, now it will be external interference endangering national security, and organizations engaging in activities endangering national security. So it's stated clearly that the activities must endanger national security before someone falls foul of the law. Now, I have looked up similar offences in other places, Australia, Singapore, and so on. They do have similar provisions to define the circumstances that constitute interference by external forces. So I'm happy with the proposed amendment, and I thank the Secretary for amending the title so that it's now more precise to refer to external interference endangering national security. I think we need to do more publicity so Hong Kong will be able to continue with the various international activities. I still have a bit of time. I'd like to talk about Clause 93, cancellation of Hong Kong AR passports. Now, the original wording is for the absconder, the person must not appeal or must not apply for an SAR passport again. But then the Secretary explained that there's extraterritorial effect. If someone has absconded to the UK or Australia, you can't really, and because there's no extraterritorial effect, so you can't really order the person not to apply for an SAR passport again. So we need to make the clause clear to say that this clause does not apply to this type of persons, and I thank the Secretary for taking on board our views. Thank you. Mr. Jeffrey Lam. Thank you, Madam Deputy. I'd like to talk about 76 and 77. Consultation with lawyers in view of circumstances endangering national security. When I read the provisions, clauses 76 and 77, I note that the term lawyer is used. Now, in other provisions, for example, clause 47, clause 74, it says solicitor or counsel. So there is worded differently. And there will be a serious impact when the bill becomes an ordinance. That's why I pointed out to the Secretary that for Cap 159 legal practitioners ordinance, there is no definition for lawyer. But then for the Chinese term lawyer, lessee, that is clearly stated as solicitor. Solicitors and barristers, of course, operate very differently. The current term of lawyer could be interpreted to mean that the lawyer only refers to solicitors but not barristers in clauses 76 and 77. After discussion, the administration took on board my view, so the term lawyer is replaced by legal representatives, because it is more comprehensive that way. And this amendment could plug the loophole and prevent anyone from, bickering on this point. Now, we all know that if we have clearly worded provisions, this is very important for good business environment. And then clause 89. Prohibition in connection of joint ventures or partnerships with relevant absconders. I conveyed the views of the business sector in the BC meeting. Now, say if someone has entered into a contract or agreement with someone before the person absconded, or there is a partnership or joint venture with the absconder entered into before the person absconded, then such contracts or obligations must not be affected. This is important protection to improve the business environment. So the administration clarified that point further, and this helped to allay the concerns of the business sector, because in Hong Kong there are many joint ventures and partnerships. For the normal businessmen, they wouldn't know that their partners have become criminals. And so this amendment is most important to bring in for investors from outside Hong Kong, because then they know that the legal system in Hong Kong is transparent. Now, this is something of great concern to the business sector. I'm glad to see that the administration has taken on board our views. The amendment now clearly defines the offense, and it also includes reasonable exceptions. For certain individuals or organizations, now they are no longer able to smear Article 23 legislation and mislead the public. Now, in the whole process of deliberations, we can see that it's been open, transparent, and fair, as well as just. Taking this opportunity, I'd like to thank Mr. Martin Liao, the chairman, and Mr. Gary Chen, the deputy chairman, for for allowing each member to speak. He didn't stop us at all. And I must thank the SJ and the Secretary for Security and their team for working endlessly. They work day and night. If they're not able to answer a question immediately, they would always give a response the next day. So they're most efficient. So after the passage of the bill, I will work together with the business sector to actively explain the bill to foreign chambers of commerce or foreign businessmen. I speak in support of all the amendments to the bill. Thank you. Mr. Martin Liao. Deputy Chair, I declare I'm a member of the Executive Council. I'm glad to see that the administration has taken on board members' views. Among the amendments to safeguarding national security bill, there's the new clause 106(a), that is, the Chief Executive in Council may make subsidiary legislation for safeguarding national security. Now, subsidiary legislation does not go beyond the scope regulated by the principal ordinance. It's just about spelling out the implementation details in relation to the principal ordinance. Subsidiary legislation is a common practice in Hong Kong. In other jurisdictions such as the US and UK, they often use this approach. For 106(a)(2), it says that any subsidiary legislation is only for the purpose of safeguarding national security. It is also for the more effective carrying into effect of, say, the interpretation of the NPC Standing Committee of Articles 14 and 47 of the Hong Kong NSL. And then the subsidiary legislation is subject to negative vetting by the Legislative Council. So the Council, the Legco, has the power to amend or even repeal the subsidiary legislation. And if there are any issues with the subsidiary legislation, there could be judicial review. The judicial organs may then rule whether the subsidiary legislation has gone beyond the scope of the principal ordinance or whether it's in contradiction with the basic law, such as protection of human rights. Now, I believe this is appropriate for the Chief Executive Council to make subsidiary legislation for safeguarding national security. The Chief Executive has an important duty in safeguarding national security. And what is important is that for clause 106(a), it is a forward-looking clause to respond to unforeseen challenges regarding to national security. And then there is this mechanism for Hong Kong to neutralize such threats that's in line with public interest. Now, next I want to talk about Clause 107 capital A, judgments and decisions of National Security Committee. On the concrete powers and duties for safeguarding national security are given to the Hong Kong SAR. So that's why there's the National Security Committee. And then the other law enforcement agencies and the judicial organs and so on, they all form part of the national security set up. The Secretariat of the MPCSC has made an interpretation of Articles 14 and 47 of the Hong Kong SAL. So that's to further explain the powers of the National Security Committee. So when the government deals with national security issues, there is a law to go by. And also the National Security Committee is given the power to judge and decide whether an issue relates to national security. The proposed amendments to the bill ensures convergence with the Hong Kong NSL. It clarifies the role and functions of the National Security Committee. It gives play to the spirit of the MPCSC interpretation, so that it makes sure that there is support and assistance of the work of the National Security Committee. I'm sure after the amendment, the judgments and decisions of the National Security Committee will be given more clearer legal power effect. Now the bill, there will be full true convergence and compatibility as well as complementarity between the bill and the 528 decision and the Hong Kong NSL. I speak in support of the two amendments and the other amendments moved by the administration. Thank you.
Mr. Chen Xiuhong. Thank you, Madam Chair. I'd like to speak about the top-level design of the enforcement mechanism stipulated in the bill. The purpose of the bill is to fully implement the May 28 decision as well as the constitutional duty stipulated in the Hong Kong NSL. The bill is also to improve the legal system as well as the enforcement mechanism to safeguard national security. As mentioned by the Secretary for Justice, the legislative exercise shows that the bill achieves convergence and compatibility with the Hong Kong NSL. In the original bill, Part 8, it is about improving the legal system and the enforcement mechanism. The original part talks about the administrative instructions to be issued by the Chief Executive. The CE may issue an administrative instruction to any public servants, but it falls short of giving the power to the CE to make subsidiary legislations in this regard. The CE, as the chair of the National Security Committee, plays an important role. However, there was no mention in the original version the role and positioning of the National Security Committee. With unforeseeable national security risks, the original version was not forward-looking enough. I'm glad that the administration took on board our views and added Clause 106A, which is about CE in Council, making subsidiary legislation for safeguarding national security. This perfects the bill, and this allows us to address unforeseeable national security risks that may emerge in the future. Also, in Part 8, the administration added the part about National Security Committee, stating that anyone, when safeguarding national security, must comply with the decision made by the committee. The MPCSC adopted its interpretation on Articles 14 and 47 of the Hong Kong NSL, but this is not reflected in the original version. I'm glad the administration now incorporates our proposals to reflect that the bill achieves the convergence, compatibility, and complementarity between the bill and the May 28th decision. This will allow us to effectively cope with complex national security risks that we may face in the future. After the passage of the bill, what is important is that there should be enough education and publicity in the community level. I'm glad to see that 107A is added to the bill. The Chief Secretary for Administration may provide advice or give any direction to any person whom the Chief Secretary considers appropriate for promoting national security education, raising the awareness of residents of the Hong Kong SAR of national security. Madam Chair, the amended bill shows the sovereignty of the central government, and it also shows that we enjoy a high degree of autonomy. Now, with the complex geopolitical situation and ever-changing international landscape, there may be unforeseeable national security risks that may emerge in a form that is unimaginable. I hope the bill can be passed soon so that we can plug the national security loophole. Thank you. I so submit. Mr. Kisanyang. Thank you, Madam Chair. I will speak about the amendments concerning absconders, that are clauses 88 and 93. Acts and activities endangering national security are serious. People who violate the law and abscond make the situation worse. Mr. Kwok Weng Han, Mr. Nathan Law, Ms. Agnes Chow were some of the examples. They are all absconders and they are now in foreign countries bad-mouthing Hong Kong. The bill proposes imposing restrictions on absconders, including cancelling their Hong Kong SAR passport, revoking their professional qualifications, and removing their office of director. These are all reasonable and they are in line with our law. However, the public is concerned about whether innocent people would be affected. On scrutinizing the part about immovable property, we were concerned that the third party would commit an offense when the third party had leased a property from an absconder before the absconder is specified by the Secretary for Security. While the Secretary for Security could grant a license under special circumstances, I'm glad the administration is adding clause 88(6) to the bill. It states that if a person does an act mentioned in subsection 2 under a contract, agreement, or obligation that arose before the date on which the relevant absconder became a relevant absconder, the person is not to be regarded as having contravened that subsection by reason only of that act. This clearly tells the public that innocent people would not be affected under these circumstances. On cancellation of Hong Kong SAR passports of absconders, this would prohibit the absconders from obtaining another nationality within a short period of time. While scrutinizing the bill, members were of the view that clause 93, which concerns cancellation of Hong Kong SAR passports, the relevant appeal mechanism is not applicable. Instead, this should be made clear, because a person should not appeal against the cancellation. We're glad that our views have been taken on board by the administration. I mentioned in the meeting, in case of an absconder having the passport being cancelled, how would the person be able to surrender himself as he returned to Hong Kong? The Secretary made it clear that application could be made in this regard. So in case the absconder wants to turn over a new leaf, there is relevant arrangement for that. I'm not going to go into the details here. To put it simply, the administration has fully considered views raised by members of the Bills Committee. I understand that the administration has worked day and night to amend the bill, and that the amendments proposed by members were all incorporated in the proposed amendments. I would also like to thank the Secretariat of this Council for completing the report of the Bills Committee within such a short period of time. We, A4 Alliance, give our full support to all the proposed amendments. Thank you. Mr. Tommy John, Deputy Chair, I'd like to speak about Clause 89 of the bill. There is an amendment in relation to prohibition in connection with joint ventures or partnerships with relevant absconders. Subclause 6 is added here. It states that if a person does an act mentioned in subsection 2 under a contract, agreement, or obligation that arose before the date on which the relevant absconder became a relevant absconder, the person is not to be regarded as having contravened that subsection by reason only of that act. This is to minimize the impact on third parties, including those who have previously established or invested in a joint venture partnership or any like relationship with the relevant absconder. This amendment helps boost the confidence of the business sector. Over the years, people in Hong Kong has enjoyed freedom in doing businesses and establishing partnership. Regardless of people's race or political stances, we all were able to enjoy this freedom. One party that commits an offense would not affect the other innocent party. All along, this has been the case under our common law systems. This provision clearly exempts the responsibility or liability of an innocent third party. So I'm glad the administration has taken on board the views of the business sector. Before we started scrutinizing the bill, I actually talked to the administration. I said the public consultation on the bill should be compiled into a form of a textbook as a teaching material for civil servants. At that time, we had yet to commence the scrutiny of the bill, but I think it was necessary to compile the materials. Now I hope that a teaching material can be compiled by the administration. I've been working in this council for 24 years now. I have scrutinized quite a number of bills. I've never seen the administration sending a whole team of officials to come address members' questions, be it people who are in charge of a bill or officers from the CMAB. I had never seen such a dedication. During the scrutiny of the bill, there was no need for us to repeat our questions because the administration was well prepared and was ready to respond to the questions. The administration was able to consider our views and give a response to all our views. I've been a member for this council for quite a number of years. I've seen a lot of newly joined members. These newly joined members were elected under the approved electoral system. I think they are of very high quality. I'm not just referring to one or two of them. All of these newly joined members are very high quality. I'm honored to be able to take part in the scrutiny of this bill, and this is a historic moment for the Liberal Party. I feel honored that I'm able to witness this. I'd like to thank the Secretariat for their hard work. Thank you.
Mr. Lai Tong-kwok, Deputy President, I will continue to speak on the amendments moved by the government. Cancellation of passports. Now, the clause specified that for those absconded specified by the Secretary for Security, the passports would be cancelled. Now, we noticed that in subclause 3, the reference to Hong Kong SAR passports may cause confusion. Similarly, during the period when the abscondent is overseas, when the person applies for renewal of Hong Kong SAR passport, how should we deal with the application? According to the existing legislation, can the Director for Immigration make the appropriate arrangements for the application? So there was sufficient discussion on this point between the Bills Committee and the government, and we reached a consensus. The administration accepted our recommendation to amend Clause 93 to enhance the mechanism. It explicitly spells out that any application for HKSAR passports submitted by an absconder would be invalid. In other words, even if the Director for Immigration received such an application in accordance with Clause 93, the Director of Immigration does not have to entertain the application, so there is no issue of rejecting the application at all. At the same time, the absconder cannot file an appeal concerning the decision made by the Director. With that, we have plugged all the loopholes. Next, specified absconder. Another member has also spoken on this. 86(2), subject to certain conditions, Secretary for the Security can specify a person as an absconder by way of gazette. In doing so, the Secretary for Security must ensure that a series of conditions are met in accordance with the law. One condition being that the magistrate has issued a warrant of arrest 6 months before. The Secretary must reasonably satisfy that the person has absconded before exercising this power. That gives rise to a question: why does the Secretary have to wait 6 months? A warrant of arrest has been issued. Why are we still allowing the absconder to be at large overseas? That doesn't make sense. The government has studied our suggestions in detail, and it agrees that the 6-month requirement is too restrictive. We should offer the maximum flexibility to the Secretary for Security to deal with these absconders. I'm pleased that the government has agreed to a proposal so that the tools available for the Secretary are enhanced. Now, textual changes. Cross-boundary will be changed to leaving the departing conveyance. Now, concerning possession of state secrets on leaving Hong Kong, now departure conveyance is mentioned. This refers to the conveyance used in the journey. In English, it is departure conveyance or cross-boundary conveyance. Now we can see that the term in English cross-boundary rather than cross-border would give rise to misinterpretation. So we propose to change the term to departure. The government has accepted our suggestion. Now these are examples that in the scrutiny process, the government has been very careful and serious. Thank you. Dr. Kennedy Wong. Chairman, I speak in support of Part 8, that is Clause 108, National Security Mechanism and Safeguards. Now, the text was, a public servant must provide all such assistance that is necessary for the work on safeguarding national security, and that's it. At the committee stage, or at the Bills Committee, I asked whether we should provide a more detailed requirements on public servants' duty to uphold national security. We have hundreds of thousands of public servants. They enjoy considerable power. So this is the amendments. According to the government, the amendments are made on the view that despite the clause has specified that all necessary assistance would be provided to a public servant on safeguarding national security, the provision should be enhanced and the duties should be made clear. So I thank the government for this amendment. Subclause 2 and 3 were added to the clause. Subclause 2, a public servant must provide any department or agency that is responsible for the work on safeguarding national security and its personnel in the HKSAR with all reasonable facilitation, support, backing, and protection in a timely manner, including providing the necessary manpower and other necessary resources in a timely manner. Subclause 3, a public servant must exercise all powers and discretions that the public servant has, including any power and discretion concerning the giving of any exemption, to discharge the obligation under this section. With this amendment, we can prevent certain public servants, on whatever reason, from procrastinating the fulfillment of their duty on safeguarding national security. So I applaud the amendment. Chairman, I feel greatly honored to be part of the Bills Committee on Safeguarding National Security Bill. With this opportunity, I thank all other members in the Bills Committee, the administration, in particular the Secretary Bureau, the Security Bureau, and the DOJ, and for their highly effective work, and also the Secretariat for its assistance. Thank you. Mr. Stanley Ng. Chairman, I continue to speak on national education. National education is an important measure to uphold national security. With better publicity and education, we can ensure that the awareness of the public in safeguarding national security is heightened. And also the public can understand the meaning of holistic view on national security. The government will make a commitment to take forward national security education. I thank the government for accepting my suggestion to add Clause 107B, empowering the Chief Secretary for Administration to coordinate and implement national security education in Hong Kong for creating a foundation for national security. And no matter how well we draft the law, implementation and public acceptance are the keys. We have to create an ambience for upholding national security. Members of the public must report any suspicious behaviors. We have to build up an immune system against national security risk. I look forward to the government taking forward the publicity work immediately after the passage of the bill so that everyone will understand the new provision and their duties under it. They must understand the benefits and importance of national security so that everyone can become a team member of the rebuttal team against smearing and false information and actively uphold national security. Chairman, we have to legislate to safeguard national security. Now, according to the anti-China destabilizing elements, they would think that without national security law, they can do whatever they want, and it is not illegal. Now, without the legislation, we will be shackled every step of the way when we try to safeguard national security. I'm pleased that today, finally, we can plug the loophole and make up for the shortcomings. The amendments specified more clearly the targets under the law. The law specifies that the targets are just those anti-China destabilizing elements who endanger national security and the external forces they collude with. Guilty or not guilty, culpable or guiltless, there are clear definitions in the law. Now, for lawful activities, business, financial services, and media reports and so on, there are better safeguards. Foreign investors will have more confidence in our system. It is a more favorable business environment for mainland and foreign investors alike. We can consolidate the foundation of stability and achieve prosperity. Chairman, once again, I give my support to the bill and the amendments. I'm thrilled that we are finally completing the constitutional obligation and that we are turning a new page in history. Mr. Tong Li-Chek, Chairman, I will focus on Part 8 of the law, that is the mechanism for safeguarding national security and irrelevant safeguards. To effectively safeguard national security, besides law enforcement and prosecution, the unity of the civil service, their cooperation, publicity and education are all very important. Now, Clause 107 sets out that the chief executive may issue administrative order or direction to implement the directions issued by the central government in terms of national security. And also the chief executive may issue direction on any necessary matters. Now, it seems that the provisions are not comprehensive enough. There are lots of statutory and public bodies subvented with public money. They have an important role to play in terms of safeguarding national security. Those who are working in these organizations, although not public servants, also have a duty to uphold national security. Now, according to the amendment, the chief executive will require these organizations to comply with the administrative orders issued by the chief executive. It rendered the law more comprehensive. Now, Clause 108, public servants to assist in work on safeguarding national security. The original provisions are too general. Those with ulterior motives may make use of the loophole and pay no heed to orders issued by the chief executive. They may take these tasks half-heartedly and put up soft resistance and jeopardize the mechanism for safeguarding national security. I'm pleased that our suggestions were accepted. According to the amendments, a public servant must provide all reasonable facilitation, support, backing, and protection in a timely manner, including the necessary manpower and necessary resources for the work on safeguarding national security. This is a much more comprehensive way to term the provision. Now, as the Bills Committee stage, I asked the governments whether the contents of these administrative orders would include national security education. Now, it gives rise to the new Clause 107B, which specifies that the Chief Secretary for Administration may provide advice or give any direction to any person for promoting national security education, raising the awareness of residents of the HASAL of national security and of the obligation to abide by the law.
I think this is an important provision. As long as more people, especially young people, are made aware of the need to safeguard national security and to abide by the law, everyone will obey the law, and more importantly, they will act on their own volition to safeguard national security, be it Article 23 legislation or the Hong Kong national security law. They will not be invoked in the future, and that we can maintain long-term prosperity and stability in Hong Kong. As one of the 15 members of the Bills Committee, President, I feel honored. We've had marathon meetings to examine the bill. All members worked wholeheartedly and diligently. They put forward questions, and the administration likewise gave us detailed explanation to allay our concerns so as to further improve the bill, so that the Hong Kong SAR can fulfill its historic mission and constitutional duty by Article 23 enactment. I support the committee stage amendments moved by the Secretary for Security. Mr. Holden Chow. President, I'd like to comment on Clause 111. This clause relates to protection for officers handling national security cases to prevent them from falling victim of doxing cases. Now, in the scrutiny of the bill, we referred to some cases involving officers not handling national security cases in the moment, but had previously handled national security cases before. And it so happened that in order to take revenge, a defendant in a national security case might take the opportunity of another non-national security case to go after the officers concerned. Well, there was a heated debate on this point during the deliberations, because during black-clad violence, the anti-China elements made threats and engaged in doxing involving the officers handling national security cases as well as their family members. Now, we spoke at length at the Bills Committee on this point because we wanted to make sure that for officers handling national security cases, including those who are handling the cases or those who have handled the cases before or will be doing so in the future, they will be given the necessary protection. I thank the administration for heeding our views and making some major amendments to Clause 111 so as to address our concerns and offer protection to these officers. So I thank the administration. I'd also like to thank the 15 members of the Bills Committee. While day in, day out, we focused on scrutinizing the bill, we also put forward some really constructive comments. I thank Mr. Martin Liao and the Deputy Chair for their leadership so that the Bills Committee could complete scrutiny of the bill with great efficiency. Mr. Gary Chan. Thank you, Chairman. I speak in support of the committee stage amendments to Clause 108. The original reads, public servants to assist in work on safeguarding national security, with emphasis on assist in. So I think this is the crux of this statement, assist in. So how do we make sure that public servants will assist in the work on safeguarding national security? Express provisions should be provided. As we all agree that we have an excellent civil service in Hong Kong, they form the core of this administration, and they are primarily responsible for safeguarding national security. I think clear requirements and directions should be spelled out in this ordinance to make sure that public servants will do their duty and safeguard national security. The original clause reads, must provide all such assistance that is necessary for the work on safeguarding national security. But this statement lacks details. I propose amending this clause such that details can be provided on how a civil servant must provide all such assistance, so on and so forth. Now, the administration has accepted my suggestion. In other words, a public servant must provide, so on and so forth, with reasonable facilitation, support, backing, and protection in a timely manner. That is to say, the public servant should give priority to assisting in the work on safeguarding national security as their primary duties. Now, in the amendment, it is also prescribed that a public servant should provide the necessary manpower and other necessary resources in a timely manner. In another subclause, it is said that the public servant must exercise all powers and discretions that the public servant has, including any power and discretion concerning the giving of any exemption to discharge your obligation under this section. That means the public servant will be made aware of the important role they play in safeguarding national security. This is the top priority. This can help address the issue of unclear delineation of work and perfunctory response to safeguarding national security. So the amendments to Clause 108 have addressed members' concerns. And by moving this amendment, the public servants can safeguard national security in a more effective manner. Chairman, I'd like to take this opportunity to thank the Secretary for Justice, Secretary for Security, as well as their team. We'd also like to thank the Legco Secretariat for their hard work, so that with great efficiency we have been able to complete the 40+ hours of scrutiny. I thank Mr. Martin Liao as Chair of the Bills Committee for leading members through this laborious process. This is an arduous but meaningful task. It is of historical significance. Does any other member wish to speak? If not, I call upon the Secretary for Security to speak again. Secretary. Chairman, these amendments are moved in relation to the issues raised by members of the Bills Committee. I thank members for their support of the bill, and I also thank them for the invaluable views so that we can further improve this bill on safeguarding national security with greater precision. I note that members who have spoken are in support of the amendments, in particular in relation to the powers given to the CN Council in making subsidiary legislation on the offence of incitement to disaffection, as well as the scope of public servants in the relevant offence. On the offence of espionage, members also fully agree that the definition should be deleted and the term should be understood in a common sense. In relation to the public infrastructure covered under the offence of sabotage endangering national security, members in general welcome the relevant provision which clearly states that public infrastructure should include public transport infrastructure, logistics infrastructure, and infrastructure for financial services in Hong Kong. As for the offence of external interference, it will be renamed as external interference endangering national security. The elements of the offence remain unchanged. On the improper means covered under this offence, I noticed that members support the amendment of the terms mental injury and mental pressure to psychological harm and psychological pressure. Members also agree to the amendments proposed for provisions concerning prohibited organizations. They include those that offer protection to people who take part in the winding up of a prohibited organization for legitimate reasons. Members also agree to the amendments to the Companies Winding Up and Miscellaneous Provisions Ordinance, which deal with the situation in which a member of the company may need to participate in the winding up of the company after it has become an unlawful society. With the amendments, the person concerned would not breach the law merely because he takes part in the winding up in the capacity of a member of the company. Members also agree to the proposed provisions that regulate shadow organizations. On the magistrate's power to adjourn a hearing for a reasonable period, members agree to specify the meaning of a reasonable period in the ordinance. Considering the national security risks absconders may potentially bring, members agreed to delete the requirement that measures can only be taken against absconders 6 months after a warrant of arrest has been issued. There is a majority support from members on this point, and it will stipulate that an application for an Hong Kong SAR passport made by an absconder will be deemed invalid. Meanwhile, in order to protect third parties, members also agree to stipulate that third parties is not to be regarded as having contravened the ordinance by reason only of entering into any contract, agreement, or obligation before the person becomes a relevant absconder, and stipulate that anyone can, in accordance with the laws of Hong Kong, the company's memorandum of association rules, or any other document, to exercise any powers against a relevant absconder. On effectively reflecting the role of the Chief Executive, National Security Committee, and the Chief Secretary for Administration in safeguarding national security, I'd like to reinstate that the amendments have added the following clauses. First, empowering the Chief Executive in Council to make subsidiary legislation for safeguarding national security. And two, if the law of the Hong Kong SAR confers any function on a person, any person in making any decision in the performance of the function must respect and execute the judgments and decisions of the National Security Committee. 3. The Chief Secretary for Administration can give any direction to a person he deems fit in respect of public communication, guidance, supervision, and regulation of the work on safeguarding national security. Members are concerned about the doxing risk for officers on national security cases. Members support a proposed extension of safeguards for officers to non-national security cases when a party to a case also stand accused of national security charges in another case. Members also support the other additional provisions, such as specified court may, on application, take anonymity measures and the offence of breaching the order prohibiting the disclosure of articles. Chairman, the deliberations of this bill and amendments are the result of joint effort of the Government and the Legislative Council. This shows once again that with a rational and pragmatic platform for policy discussions, the Legislature and the Executive can deliver for our country, people, Hong Kong and our people. And we can surely roll out laws and policy measures safeguarding national security and ensuring Hong Kong's prosperity and stability. I reiterate that these amendments have had the Bills Committee's support. So once again, I urge members to support these amendments. I so submit. Thank you, Chairman. We will now vote on the clauses with no amendment standing part of the bill. I put the question to you that the clauses with no amendment as set out in the appendix to the script stand part of the bill. Will those in favour please raise your hands? Those against, please raise your hands. I think the question is agreed by a majority of the members present. I declare the motion passed. The committee now deals with the clauses and headings with amendments. Secretary for Security, you may move your amendments. Chairman, I move the amendments set out in the appendix to the script. I propose the question to you, that is, that the Secretary's amendments be passed. I now put the question to you as stated. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the amendments passed.
Clauses 3, 6, 12, 15, 19, 28, 32, 38 to 41, 45, and 47. The heading of Part 6. The heading of Division 1 of Part 6. Clauses 50, 53, 56, 59, 60, 72, and 74. The heading of Subdivision 2 of Division 1 of Part 7. Clauses 76, 77, and 80. The heading of Division 2 of Part 7. Clauses 86, 88, 89, 92, 93, 102, 107 to 109, 111, 119, 122, 126, and 158 as amended. I now put the question to you that the clauses and headings as amended just read out by the clerk stand part of the bill. Would those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. This committee now deals with the new clauses. New Clause 19A, Specification of Public Officers. New Clause 29A, Specification of Public Officers. New Clause 63A, Shadow Organizations of Prohibited Organizations. New Clause 106A, Chief Executive in Council may make subsidiary legislation for safeguarding national security. New Clause 107A, Judgments and Decisions of National Security Committee. New Clause 107B, Provision of advice or giving of directions in relation to national security, education, etc. New Clause 113A, Specified court may make application take anonymity measures. New Clause 113B, Offense of contravening order prohibiting disclosure of identity. New Clause 177A, Section 26 amended, disqualification from voting. Secretary for Security, you may move the second reading of the new clauses. Chairman, I move the second reading of the new clauses just read out by the clerk. I propose the question to you that the new clauses read out by the clerk be read a second time. And now put the question to you as stated. Would those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. New clauses 19A, 29A, 63A, 106A, 107A, 107B, 113A, 113B, and 177A. Secretary for Security. Chairman, I move that the new clauses just read out by the clerk be added to the bill. I propose the question to you that the new clauses read out by the clerk be added to the bill. I now put the question to you as stated. Would those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. In accordance with Rule 58(a) of the Rules of Procedure, this committee now deals with the preamble to the bill. I put the question to you that this be the preamble to the bill. Would those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. All the proceedings on the Safeguarding National Security Bill have been concluded in Committee of the Whole Council. Council now resumes. Secretary for Security. President, I now report to the Council that the Safeguarding National Security Bill has been passed by Committee of the Whole Council with amendments. I move the motion that this Council adopts the report. I now propose the question to you that the Secretary's motion be passed. I now put the question to you as stated. Would those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Third reading. Safeguarding National Security Bill. Secretary for Security. President, I move that the Safeguarding National Security Bill be read the third time and do pass. I now propose the question to you that the Safeguarding National Security Bill be read the third time and do pass. Mr. Ronnick Shen. President, on behalf of the 18 other members of G19, I support the passage of the third reading of the Safeguarding National Security Bill so that we fulfill the constitutional duty under Article 23. We plug this loophole in our national security. The other 18 members and I are honored to be able to be part of this historic mission. Whatever challenges may come in the future, we will remain steadfast in upholding national security. We will defend this law. Once we have this protective barrier, we will see a more stable business environment. Hong Kong will be a safer place, a more open place, and more inclusive place, so that we can then zero in on the economy and deliver a better life for people. And then we can go from stability to prosperity. Everyone in Hong Kong will be able to go about their lives. I so submit, I support the passage of the third reading. Mr. Ben Chen. President, legislation for Article 23 of the Basic Law is a constitutional duty of the HKSAR. We have come to this juncture of great historic significance. The DAB hopes that Legco can pass this Safeguarding National Security Bill so that this can be a significant gift for the upcoming 27th anniversary of Hong Kong's return to our country. Safeguarding national security is the prerequisite for a good life for people in the city. We support this bill so that we can cope with the past, present, and future national security risks and challenges. At the same time, we must improve the legal system and enforcement mechanisms for keeping our country safe. We need to stick to the May 28th decision of the NPC and also the national security law. We need to build up this protective barrier to keep our country safe. President, we need to keep our country safe. Only then we can keep Hong Kong safe. We need to keep our country safe, and only then we can keep our community safe. On behalf of the DAB, I support the passage of this bill so that Hong Kong can go ahead with the peace of mind to develop its economy and improve people's lives. I so submit. Mr. Andrew Lam. President, I represent the C15 Plus group. We support the passage of this bill so that we can complete our constitutional duty of safeguarding national security. The stronger our protective barrier, the stronger the belief in one country, the better we can leverage the two systems, the greater prosperity we can encourage. As we are going our last mile in this work, I thank the Bills Committee's chairman and the members for driving the work. I thank the government officials and departments for doing their respective jobs. Everyone's doing their best on this legislative exercise. The C15 Plus members and I look forward to voting on this bill so that we can take part in and witness this historic moment. Mrs. Regina Ip, on behalf of the 6 members from the New People's Party, I express my support for the early passage of this bill at the third reading. This is a great demonstration of the practice of one country, two systems. Before 1997, the central authorities gave us room. The central government gave us the opportunity to legislate on our own for Article 23. That shows great accommodation that the central authorities has shown. More than 26 years of delay, we are finally here. We are completing our constitutional duty. Just like other members, I believe once this bill is enacted, we will see greater development. The government will be able to better focus on the economy and improve people's lives. And we will also promote this law as a law that is in line with human rights protections and the international covenants on human rights. This can also show that this law is in line with the rule of law. I so submit. Mr. Peter Shiu. President, on behalf of the Liberal Party, I reiterate the support of the Liberal Party for this bill. Businesses have told me this bill can plug the loophole in national security. This law will also converge with the national security law. We will build a stronger protective barrier and also leverage the unique advantages we have under one country, two systems. The Liberal Party is pleased to see that we have come to the final step of this legislative exercise. We're close to completing the legislation. Then this is a profound moment. With this enactment, we look forward to seeing long-term stability. And then we can have peace of mind and focus on the economy and improve people's lives. We can also contribute to our country's prosperity. Mr. Kingsley Wong. President, on behalf of the FTU, I speak in support of this bill. Back in 2002, the FTU and other groups expressed their support for legislation for national security to fulfill Hong Kong's constitutional duty. 22 years later, this collection of groups supporting the legislation are finally seeing the completion of the job. Different labor groups unanimously support the passage of this bill. This points to the necessity and importance of the bill. More than 98% of the respondents of the public consultation support this bill. Getting this bill through means responding to those popular calls. This bill can help us meet national security risks. We can remove the barriers to our development. We can then focus on the economy and improve people's lives. Everyone can lead a good life in the city. I so submit. Dr. Lo Wai Kwok. President, legislating for Article 23 of the Basic Law is Hong Kong's constitutional duty. This is also about protecting Hong Kong, ensuring peace and stability in Hong Kong, in our country. This bill is also in line with the rule of law. The bill strikes a proper balance between national security and protection of human rights. We are finally here at the third reading. The BPA supports this bill, and we are most honored to be able to cast a vote of support for this bill. This bill is overdue for more than 20 years, and we're finally at the final step. We are honored to be part of it. And we also have mixed feelings. This is a day to be remembered. I so submit. On behalf of the BPA and businesses we represent, and also the public, we support the passage of this bill at third reading. Ms. Dory Lim. The Safeguarding National Security Bill has gone through the second reading. Members have spoken. We have taken on board the comments, suggestions from all walks of life. We have also seen the government adopt the suggestions. Now we have come to the bill as amended. We have come to the third reading of the bill. I thank the public for their attention to this bill. I thank the government officials and their team for working tirelessly on this bill. I also thank all Legco members, the Legco Secretariat, for their work on scrutinizing the bill. With the bill's passage, we are finally completing the constitutional duty to our country, to the people, and we're finally plugging the loophole in national security for more than 20 years, and we can ensure security for our city and for everyone. After this bill is passed, we can work together and focus on the economy and better integrate into our country's development, especially the Greater Bay Area development. We can improve people's lives and contribute to our country's development. And then we can continue to leverage our strength with our country's support and global connectivity, and we have a bright future. With this bill's passage, we are only reaching a new start. We still have to work on national security education. We still have to explain the new law. Everyone needs to play their part. Our officials also need to do their job. We need to tell the outside world about the new law. I support this bill so that we can all work together on completing the constitutional duty.
Does any other member wish to speak? Secretary for Security, would you like to speak? Secretary, please. President, over the past week, the Council held back-to-back meetings to scrutinize the bill. Now, the bill is soon to be read for the third time. As the official in charge, my feelings are mixed. On one hand, I'm thrilled to witness the birth of Article 23, my own flesh and blood, my child. On the other hand, I lament the years of toil and frustration preceding the birth of the bill. We are able to witness the birth of Article 23 today. It is because of the hard work of the government and the Legislative Council. And more importantly, it is because the members of the public understand the importance of the legislation for prosperity in Hong Kong. After the 2019 Colour Revolution, there is a consensus that upholding national security, sovereignty and development interests is the key to our long-term success. Having witnessed the stabilizing effects brought about by the Hong Kong National Security Law, there is a solid popular opinion that we should engage in legislation for national security. The bill has swiftly proceeded from conception, public consultation, to today's council debate. This is the last step. The credit belongs to the entire team. Before it is put to vote, I would like to thank the leadership of the Chief Executive and his support from central authorities, as well as the entire civil service, as well as the DOJ and the Security Bureau's colleagues who worked tirelessly to draft the law, scrutinize the bill, and explain the bill. That's why we can complete the extraordinary task in time. I also thank the President, Bills Committee's Chairman, BC members, as well as every member. Your invaluable views are very important for the legislation as well as the implementation of the law and our national security work. I have to thank political parties, groups, and friendly bodies outside the Council, which mobilize members to explain the bill to the general public. They also mounted strong rebuttal against groundless smearing and sent a positive message. I thank the general public for supporting the implementation of Article 23, the 528 decision, as well as the Hong Kong NSL. We are fulfilling a constitutional duty. Your support means a lot for us. This will also ensure the steadfast success of one country, two systems. With the passage and coming into effect of the Safeguarding National Security Ordinance, it will complement local legislation and the national security mechanism in forming a complete legal system for safeguarding national security. But that doesn't mean that our work for upholding national security is completed. On the contrary, since resumption of second debate, many members said that after passage of the bill, we have to continue with our publicity and public education work. I fully agree with them. That's why the Secretary for Justice and myself have packed our schedule with a series of explanatory sessions to promote the relevant law to the public. We will continue to provide and update relevant information on the Internet and encourage the public to understand the law better. This is important for the smooth implementation of the law. I believe that with a complete set of legal system for safeguarding national security and also a more comprehensive understanding of national security among the public, we can enjoy long-lasting stability. President, I so submit, I implore members to support the third reading of the Safeguarding National Security Bill. Thank you. I now propose the question to you that the Safeguarding National Security Bill be read the third time and do pass. Mr. Martin Liao claims a division. The division bell will be rung for 5 minutes.
請各位議員返回。
Members, please return to your seats. Voting begins. Please check your votes. Voting is closed. There being no question, voting is closed. Please display the results. 89 present, 89 for. Unanimous. Carried. I declare the motion passed. Safeguarding National Security Bill. Members, as the President of the Legislative Council, I will not vote in usual circumstances. However, legislation for Article 23 is not just any other piece of legislation. It relates to the national security in Hong Kong. It is of the utmost importance. So at this historical moment, I will vote in favor of the bill together with you. The Safeguarding National Security Ordinance highlights the importance of safeguarding national security by every individual. I've just been informed that after the passage of the bill, in accordance with rules of procedure, 8A, the Chief Executive will attend the Council and speak to members. I'm aware that the Chief Executive is already here. I will invite the Chief Executive to enter the chamber. Please remain standing.
The Chief Executive.
歡迎行政
Welcome, Chief Executive, to today's Council meeting. Chief Executive will now address the Council. Chief Executive, President of the Legislative Council, members, this is a historic moment for Hong Kong. We've waited for 26 years, 8 months, and 19 days for today. The 6th term of the Hong Kong SAR government and the 7th term of the Legislative Council have jointly completed this historic mission. This is our moment to be proud. We've fulfilled the constitutional duty on Article 23 enactment. We've completed the historic mission. The Safeguarding National Security Bill has been read the 3rd time and been passed. This is the 10th anniversary of President Xi Jinping's holistic view of national security. This year, we completed Article 23 legislation. We've fulfilled our constitutional duty and completed the historic mission. We live up to the country's expectation. I'm going to sign the Safeguarding National Security Bill. This bill will be gazetted on the 23rd of this month. Safeguarding National Security Ordinance will come into effect on the 23rd of March 2024. Safeguarding National Security Ordinance will help us effectively prevent, suppress, and punish acts and activities endangering national security, including infiltration and sabotaging activities by external forces. We can effectively guard against color revolution and also those advocating Hong Kong independence. We will never be afraid of mutual destruction again, and for rioters to hurl petrol bombs and vandalize properties in Hong Kong, endangering the lives of Hong Kong people. From now on, Hong Kong people will never have to experience the pain that we've experienced before. There are 3 principles to safeguarding national security. These principles are set out in the ordinance. First, the highest principle of one country, 2 systems is to safeguard the sovereignty, unity, and territorial integrity of the state, and that human rights and freedoms are safeguarded in accordance with the International Covenant on Civil and Political Rights, as well as the International Covenant on Economic, Social, and Cultural Rights as applied to the Hong Kong SAR. And human rights, including the freedoms of speech, of the press, and of publication, the freedoms of association, of assembly, of procession, and of demonstration, safeguarded under the Basic Law. The 3rd principle is that for acts and activities endangering national security, there must be adherence to active prevention in accordance to the rule of law and suppression and punishment according to the law. There are also 3 objectives. That is, we must resolutely, fully, and faithfully implement the policy of one country, 2 systems, under which Hong Kong people administer Hong Kong with a high degree of autonomy. 2, to establish and improve the legal system and enforcement mechanisms for the Hong Kong SAR to safeguard national security. And 3, to prevent, suppress, and punish acts and activities endangering national security according to the law, and to protect the lawful rights and interests of residents of Hong Kong SAR and other people here, to ensure the property and investment in the Hong Kong SAR are protected by the law, and to maintain prosperity and stability of the Hong Kong SAR. There are also 4 features of this ordinance. The Safeguarding National Security Ordinance has high degree of convergence, complementarity, and compatibility with the Hong Kong national security law. Reference has been made to other common law jurisdictions in drawing up the bill. However, we also have regard to actual circumstances in Hong Kong for its implementation. Common sense approach is taken in drafting the bill. It's easy to understand, and we've also repealed obsolete provisions. On the 25th of January this year, at the Chief Executive Interactive Questions and Answers session, I announced the start of the legislative exercise immediately afterwards, on the 30th of January, I started the public consultation, which lasted until the 28th of February. The government received 13,000 submissions. 98.6% of them make positive and supportive comments. There is a strong public mandate for Article 23 enactment. I thank the Legislative Council for convening the Council meeting for the first and second reading of the bill, as well as the incessant work of the Bills Committee meeting, as well as the support of the House Committee, followed by the resumption of the second reading and third reading of the bill today. All these demonstrates the importance of this bill, and that we should enact on Article 23 as early as possible. 1 day sooner is 1 day earlier, so that we can fulfill the constitutional duty long awaited for 26 years, 8 months, and 19 days. I'd like to thank Mr. Andrew Leung, President of the Legislative Council, for his understanding of the necessity and urgency of Article 23 enactment. Early meetings and special meetings have been called in order to safeguard national security. At the same time, he made sure that there is due process. Every morning, according to the President, he would receive messages from a number of members, all discussing matters relating to Article 23 enactment. So to him, the moment he woke up to the moment he turns in, all he thought about was Article 23. He shared the same goal as other members in completing the legislative exercise, and this is motivation for all of us. I also thank members of the Bills Committee, including Chair Mr. Martin Liao, Mr. Gary Chan, Deputy Chair, and as well as 13 other members. They have worked tirelessly for 7 days. They worked from 9 a.m. to 7 p.m. every day, and they even deliberated at length on a particular provision. For example, they spent 1 hour and 20 minutes on just one clause. And there are also many clauses which took members more than 30 minutes to go through. The House Committee established a subcommittee on matters relating to Article 23 legislation, and together with the meetings of the subcommittee, 25 meetings have been held, totaling over 50 hours. Members also put forward over 1,000 questions. In the end, the administration proposed 91 amendments. Members have all dedicated their efforts to complete the legislative work with great efficiency. Mr. Martin Liao is chairman of the Bills Committee. As I understand, in order to facilitate the smooth conduct of the Bills Committee's work, he made ample preparations in light of possible matters requiring the chairman's ruling. In the end, no ruling was required because all members did their homework and the chair did not have to rule on anything. All members acted as one, and he feels encouraged by the unity of members. I also thank Ms. Dari Lee, Chair of the House Committee, and all other members for their full support of the administration's proposal for this bill to be tabled in the Council as early as possible. Ms. Dari Lee is an NPC delegate, and in fact, she traveled to and from Beijing twice during the 2 sessions. According to her, it's a very hard-to-forget experience, but hard to come by. We followed all the established procedures in going through the bill. Members have also been very serious about examining the bill. Members deliberated on a number of matters, including the philosophy of the bill and the details, so on and so forth. They all abide by the objective of completing the legislative exercise as early as possible. So we've done the work with great efficiency and with quality. This bill has been read the 3rd time, and this is the high point of patriotism. We all feel honored to have completed this important mission of safeguarding national security bill. I also thank the government for their contribution in this regard. I also thank the Secretary for Justice as well as the Department of Justice. In particular, I thank Mr. Paul Lam, Secretary for Security, Secretary for Justice, Mr. P.K. Tang, Secretary for Security, as well as other government officials. They've helped in rebutting arguments, and they've also done a lot of explanation to Legco members with dedication. I remember I called the DOJ's office and the Security Bureau's office a number of times, and by the time we ended the conversation, I took a look at the clock, and it was already 2 or 3 in the morning. And I really appreciate their dedication. They are the heroes, and I feel proud. Finally, I thank all patriots for supporting this bill and for those who support Article 23 enactment, so that we can now fulfill his constitutional duty and draw a close to what we've been waiting for 26 years, 8 months, and 19 days, so that we create a new chapter in history. With Article 23 enactment, we can better safeguard national security, so that we, after plugging all loopholes, we can all focus our energy on economic development and improving people's livelihood, so that we can build a better home for all of us. This is a historic moment. We feel proud and encouraged. And this is also a moment in which we turn a new chapter in our history. Thank you. Once again, I thank the Chief Executive for coming to this council and addressing the council in person at this historic moment. Today, we witnessed the joint efforts made by the legislature and the executive, so that we successfully fulfilled the objective of enacting on Article 23 of the Basic Law. I believe, same as everyone here, we are all confident that with passage of the bill, we can have a better future for Hong Kong as well as our country. I now invite the Chief Executive, government officials, and all Legco members, as well as all government officials and colleagues taking part in this legislative process, to stay behind for a group photo, to be a witness to this historic moment. The next council meeting is scheduled for 11 a.m. tomorrow. The council is now adjourned.
Hey，大家好，我哋